Good morning, esteemed professors, dear colleagues and friends. It is my pleasure to moderate the first session during the second day of the LAWGEM conference. And today we have plenty of work to do. We have 5 chapters to present. So I suggest that we start. There will be a slight change in the agenda for this morning session. So instead of starting with a chapter on human rights, we will start with the presentation of the chapter on international and EU law and gender perspectives of these areas of law. So Professor Tanasije Marinković, who was supposed to speak the first and the last, will only have the opportunity to address us at the end. Let me just briefly explain how we intend to work during this first session, because we have so many speakers and not that much time at our disposal. So what I would like to ask our dear colleagues and speakers is to stay within 10 minutes limit for their presentations. Also, my suggestion would be to first go through all the presentations and then to leave time for discussion at the end. Otherwise, I believe we would be in problem. So if you do not mind, I suggest that we proceed in this way. The first chapter, as I said, deals with international and EU law and gender perspectives of international and EU law. This session today will be slightly different maybe than the session yesterday, because our speakers during the morning session will not just present their chapters. We will all go into a deeper analysis of certain issues that were addressed within the chapters and focus on one specific topic, and this is women as refugees and the gender dimension of refugee law and migration law. So the first speaker for today is our dear and respected Professor Thomas Giegerich. Professor, we regret that you are not with us today here in Belgrade. It would be better if we could welcome you here live. However, we are very happy that you are here with us even online. So Professor Giegerich, you know Professor Giegerich very well, a professor at the Europa Institute of the University of Saarland in Saarbrücken. Professor, please, the floor is yours. You have our attention.
Thank you very much, and also from my side, sorry for not being able to join you in person, but only online. I shared my screen with you. Can you see my slide?
Yes, we can see it.
Oh, okay.
Works perfectly.
And you can read that I'll be speaking about using international and supranational law for closing the gender gap this morning. Public international law and supranational EU law are playing ever more important roles in a globalized world. This has also raised the importance of introducing a gender equality perspective in making, interpreting, applying, and adjudicating international and supranational law, as well as in teaching and learning it. While we have come a long way regarding de jure and de facto equality of women in international and supranational law, a huge gap between promise and reality remains there too. Narrowing that gap is not easy because the backlash against international human rights in the name of national autonomy and traditional values, which we are currently witnessing, is often specifically directed against the rights of women and non-binary persons. we need more gender sensitivity in the making and enforcement of international and supranational law, as well as national law, and for that, gender-sensitive legal education needs to be intensified. On the other hand, we must spread the word that the gender equality standards of international and supranational law are often more advanced than those in national legal systems, and that they can and should be used as benchmarks for further progress on the ground. The famous documents initiating the human rights revolution in the late 18th century were formulated by men and proclaimed the human rights of men, to such an extent that Olympe de Gouges felt compelled to add her own declaration of the rights of women in 1791. The situation is different with the UN Charter of 1945 that brought about the human rights revolution at the international level. The Charter immediately adopted the notion of equal rights of women, underlining the dignity and worth of the human person and the equal rights of men and women in its preamble. The Charter went on by declaring that to achieve international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for all, without distinction as to sex, was one of the purposes of the United Nations. The Charter obliges the United Nations to promote universal respect for and observance of human rights and fundamental freedoms for all, without distinction as to sex. And all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of these purposes. In 1948, the UN General Assembly proclaimed the Universal Declaration of Human Rights in gender-neutral terms, underlining the equal rights of men and women and the prohibition of discrimination based on sex. The declaration had been drafted by the UN Human Rights Commission, chaired by Eleanor Roosevelt. This was a good start in theory, and it was somewhat belatedly followed by the two international covenants of 1966, general human rights treaties prohibiting discrimination on ground of sex and obliging member states parties to ensure equal rights of men and women. But in practice, UN member states had to admit the obvious in 1979, that extensive discrimination against women continues to exist, so that a gender-specific convention on the elimination of all forms of discrimination against women, CEDAW, was needed. As a matter of fact, stereotyped roles for superior men and inferior women have long been deeply entrenched in the cultural and religious traditions of many societies. Thus, while CEDAW is one of the most widely accepted of the 9 core human rights treaties at UN level, it is also the one riddled with the greatest number of far-reaching and impermissible reservations by states. These states obviously fear the effective realization of women's rights and the creation of substantive equality with men, because that inevitably requires a change in the traditional role of men as well as the role of women in society and in the family, as the preamble of CEDAW expressly and rightly states. Moreover, CEDAW's implementation mechanism, a mere state reporting system, is weaker than the implementation systems in other human rights treaties. The 1999 optional protocol to CEDAW that introduced an individual complaint mechanism has so far been ratified by only 60% of the states parties to CEDAW. The unpleasant truth is that despite all these efforts, extensive discrimination against women continues to exist until this day, even more than 40 years after the entry into force of CEDAW. In these 40 years, we have witnessed barbarous acts against Bosnian, Yazidi, Rohingya, Ukrainian, and many other women, which have outraged the conscience of humankind and led to the inclusion of gender-specific offences in the Code of Crimes under international law. Obviously, one cannot, in a few decades, change attitudes that have hardened for centuries, if not millennia. But at least we have widespread agreement today that the gender gap in the effective realization of global human rights constitutes a serious problem which needs to be solved in order to consummate the human rights revolution and ensure freedom, justice, and peace in the world. In other words, there already is a high degree of gender-sensitive problem awareness, and it is growing. Thus, international public opinion is closely watching the fate of women's rights in Afghanistan after the takeover by the Taliban. The situation of women in Afghanistan has meanwhile unfortunately deteriorated so much that each and every woman that manages to leave Afghanistan should immediately be recognized as a refugee in the sense of the Geneva Convention relating to the status of refugees. Women are systematically persecuted in Afghanistan for being women, that is, because of their membership in a particular social group. All this happens despite the fact that Afghanistan has been a state party to CEDAW since 2003. Quite apart from the dire situation of women in Afghanistan, we definitely need to accelerate the frustratingly slow pace of closing the gender gap in the effective realization of human rights. And for that purpose, also make determined use of the instruments of international and supranational law at our disposal. On the regional level, only Africa has an equivalent to CEDAW, the protocol to the African Charter on Humans and People's Rights on the Rights of Women in Africa of 2003. In the Americas and Europe, we only find special treaties on the prevention and elimination of violence against women. The Inter-American Convention on the Prevention, Punishment and Eradication of Violence Against Women of 1994, and the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, the Istanbul Convention of 2011. In Asia, there is no gender-specific human rights treaty. The Arab region, which straddles Africa and Asia, has not brought forth any gender-specific treaty. But the Arab Charter on Human Rights of 2008 addresses the obligation to eliminate discrimination on grounds of sex and guarantee effective equality between men and women, as well as the need to protect women from all forms of violence or abuse in family relations. But on the regional level, all is not well either. Turkey, that had been proud to be among the first states to sign the Istanbul Convention in 2011, denounced it in March 2021, although the number of women killed there, mostly by former male partners or family members, continues to rise. The good news is that this move provoked heavy criticism both inside and outside Turkey, and that deliberations in Poland to leave the convention as well have not been pursued any further. This is an encouraging sign of gender sensitivity in transnational public opinion. In supranational law, the equality between women and men does not only feature prominently among the values of the European Union, but the EU is outright charged with combating discrimination and promoting equality between women and men. The EU has fulfilled this obligation to a considerable extent by enacting various directives. More specifically, Member states are obliged to ensure the principle of equal pay for male and female workers for equal work, and that has been part of primary law since 1958. Still, there are EU-specific gender gaps. The gender pay gap persists in the EU. Another EU-specific example for the gap between promise and reality regarding equal rights of women is the delay in the ratification of the Istanbul Convention, which the EU signed already in 2017. Only 21 member states have become parties to the convention so far. The other 6 have only signed it because in the national ratification processes, objections based on traditional conceptions of the family were raised. Apart from the question on what TFEU articles the Council decision to authorize the conclusion of the Istanbul Convention on behalf of the Union should be based, the problem is whether the Council can adopt that decision before all the member states have ratified the Convention. The European Parliament requested an opinion from the Court of Justice on that question, and the Court decided in October 2021 that it was within the discretion of the Council whether or not to wait until all the member states had ratified. In any event, the ratification of the Istanbul Convention by the EU has not yet been accomplished. A third such gap is currently about to open up. Commission President von der Leyen announced in her State of the Union address in September 2021 that by the end of the year, the Commission would propose a law to combat violence against women. On 8 March 2022, the Commission published its proposal for a directive of the European Parliament and the Council on combating violence against women and domestic violence. The Commission proposes that the EU legislature use powers pursuant to Article 82, paragraph 2 and Article 83, paragraph 1 TFEU, which would permit the Council to decide by qualified majority within the ordinary legislative procedure. But Articles 82, paragraph 3 and 83, paragraph 3 TFEU both give member states veto power to shield fundamental aspects of its criminal justice system. It is quite likely that at least one of the 6 member states that have so far refused to ratify the Istanbul Convention will use its veto to derail the proposal. On the other hand, the fact that the Commission President has made such an important announcement in her State of the Union address shows that she invests political capital on a gender issue and that she expects a political profit from it. She obviously believes that the amount of gender awareness and sensitivity has grown considerably throughout the EU. This overview of international and supranational developments demonstrates that the gap between promise and reality regarding equal rights for women is still significant, also at those levels. But at the same time, it reveals that international and supranational law have the potential to improve the situation of women by helping to overcome national obstacles and resistance. International and supranational law can lead the way by performing a role model function because these areas of the law are further detached from the cultural and religious traditions of individual societies that often prevent progress. On the other hand, that detachment inevitably lowers the legitimacy of international and supranational solutions. In order to prevent a backlash, one must avoid the impression that solutions are imposed from above. Rather, it is a matter of persuasion by opening up new and broader perspectives to as many people as possible. It should be made clear that by discriminating women societies waste talents and suffer a competitive disadvantage. Societies which treat women as equals, both in law and in fact, will be more successful in adapting to the challenges of the future. They will be healthier, wealthier, freer, and more peaceful, and quite generally more advanced. I thank you for your attention.
Thank you, Professor Giegerich, for so competently leading us through the main international instruments, both at the universal and regional level. Also, thank you for pointing to some recent developments, especially at the level of EU law in this area. The fact that you mentioned that 60% of states parties ratified the optional protocol to CEDAW obviously leads to a conclusion that there is still much work to be done in this area. Thank you for introducing us into this topic and into the issues that your chapter deals with. This actually serves as an excellent introduction to what we are about to hear from our next speaker, Professor Rigmor Argren from Örebro University, because now we will deal with the gender perspective of certain branches of international law. Actually, Professor Argren will focus on international humanitarian law and whether international humanitarian law is gender sensitive and to what extent. Professor Rigmor, I hope that you can hear us. Professor Argren, are you there? I can see that you managed to share your presentation, but we cannot hear you. Professor Argren, we cannot hear you.
Oh, I'm sorry. Good morning, everyone. I'm not familiar with the software, so I was scouting around for the switch on sound button, and I found it. Is my am I coming through clearly in speaking? I know that I sometimes need to put phones when I do this online.
For the moment, everything is okay. If there are some technical issues, I will come back to you. But at the moment, it seems to be fine.
Good.
The floor is yours.
Thank you. Thank you. And it's a pleasure to speak to you, even if I couldn't make it to see you on site. As was mentioned in the introduction, I will speak to you a little bit about international humanitarian law. And I need to emphasize that that is not part of refugee law, has nothing to do with refugees. So in that sense, it's outside of the scope of today's topic. On the other hand, it's a very basic part of international law, and it features in the chapter of international and EU law in our textbook. And if you give it a little thought, what it covers is actually what's there to protect those who didn't manage to flee yet. So on that note, let me start my presentation. I will mention a few features of this IHL. It has particular traits, and some of them more significant than others. I will speak a little bit about how women are captured in the treaties under IHL. And it falls into what is called general protection and specific protection. And I will close my contribution with a few ideas about, well, what next, where to. So I normally start here, mainly because it can give us a sense of what is armed conflict, what is war. Well, this is a painting capturing the Battle of Solferino, 1859. And this is what Henri Dunant came upon when he was traveling. And the suffering and the inhumanity was enormous. And that is in the narration of the International Committee of the Red Cross, how that organization and initiative started. Now, if we give this picture just a little bit more consideration, there aren't any women here. And maybe we don't expect that. We'll play around a little bit in our heads with that as we go on. Women did participate in armed conflict. They've always done that, but in a very particular role. It's the role of the caretaker, it's the role of the helper. Now, interestingly, even such a role has not come without battle. Women had to fight to be allowed to contribute, which is interesting. So there's this historic perception that the enormous mayhem of an armed conflict is not a sight for women, and they shouldn't even be there. That's the one side, and the other side is, oh my God, what could happen to the morale if women all of a sudden turned up on the battleground? So these are just a few ideas that have been shaping our perception about women and conflict. And some of it obviously still influences decisions. Right. So under IHL, the absolute fundamental protection comes from the principle of distinction. Any party going to a conflict, fighting a war, is obliged to distinguish between civilian population and civilian objects and combatants or military objectives. So it goes for humans and it goes for materials or objects. And this is fundamental. It's actually been referred to by the International Court of Justice as a cardinal principle. And it's actually paramount to the whole construction of IHL as a legal regime. The criteria to decide whether something is a military objective or a civilian object is determined by elements such as the nature of it, the location of it, the purpose, and the use of it. This means that it's a constant decision that has to be done by those who are in charge of commanding the attack. And this obligation, this principle of distinction, actually has a twofold obligation. So the first one is to carry out the analysis, the assessment of whether this is civilian in nature or in purpose, or whether it's military. And the second leg of this obligation then is that if anyone decides to attack, it can only be directed at that which has been determined to be a military objective. And this is the basic construct. Obviously, if in doubt, the law tells us, then we should assume that the person or the object is civilian and therefore not permissive to attack. Now, this is repeated in different ways throughout the 4 Geneva Conventions and the additional protocols to the Geneva Conventions. And it's sometimes a bit rephrased, and it's in essence, the core of it remains the same. Now, looking at what's there on women. This is an example from Geneva Convention 1, Article 12. Women shall be treated with all consideration due to their sex. So the phrasing here is actually identical to the first phrasing that occurred in the Geneva Conventions in 1929. At that time, it came under Geneva Convention 3, which covers or regulates how prisoners of war are treated. It's actually the identical wording that has then been moved over to Geneva Convention 1. And it is reflected in Geneva Conventions 2 and 3 as well. In Geneva Convention 4, which comes into place after occupation, meaning an international armed conflict that has resulted in foreign forces occupying the territory. The phrasing has been expanded, and it talks about protecting against any attack on their women's honor, in particular against rape and forced prostitution and any form of indecent assault. So what we see here is that there are certain features that seems worthy special protection in the eyes of the lawmaker. It's interesting to note that if one looks at the general comments on the additional protocols, Pictet in 1960 reflects upon what is worthy special consideration due to sex. And what he says is that no doubt is accorded to the fact that in every civilized country, to protect the one who is weaker than oneself and whose honor and modesty call for respect. So emphasizing that anyone who's weaker deserves protection. It's quite an interesting phrasing, and we'll come back to that a little bit towards the end of my presentation. So what we can see is that women are protected, worthy of protection, because of weakness, in fact, physical and psychological. And if we look at the provisions under the 4 Geneva Conventions and the treaties, women, the word women, are mentioned in 42 of the provisions. 19 of these provisions deal with matters such as pregnant or nursing mothers. So in a sense, the first type of protection or element that makes women worthy protection actually are biological aspects. And the second type of protection given to women under IHL is from sexual abuse, so a particular war crime that can be carried out against women or may happen. It's also interesting to note that the rationale for many of the provisions under IHL is the protection of the unborn child and small children, which means or could mean that women become auxiliary to their protection. It's actually not protecting the woman as a woman, it's protecting the next generation of citizens of that state, which forms the basis for special protection. So this gives us an idea that when women are protected under IHL, the basis of the protection is either they're especially vulnerable, specific vulnerabilities that women have, or because of a very particular function they have. in this case, as mothers. So again, this is a little excerpt from Additional Protocol 1. And the additional protocols are from 1977, and the Geneva Conventions from 1949. Well, there's a lot of old stuff in the Geneva Convention, so there's a lot of customary codification of customary rules. So in a sense, they go back much further than 1949. But the text that we're dealing with today is from 1949, as far as the Geneva Conventions are concerned, and the additional protocols are from 1977, which is interesting. When reading the additional protocols, it's quite obvious that we've had all this human rights movement that Professor Giegerich just introduced to us, and that has put a bit of a different language into the texts of additional protocols. But nevertheless, it still states that women shall be the object of special respect and shall be protected in particular against rape, forced prostitution, and any other form of indecent assault. So it's more of the language that has changed a bit. It's not talking about honor, but it actually spells out rape. But the substance, what the protective basis is, or the basis for what needs to be protected, remains the same. In the second paragraph of Article 76, we see that, again, it's the biological aspect of protecting women that has remained. Yeah, and it even stretches into trying to protect women from being put to death sentence. But again, actually not because of the women as such, but in her role as a mother. Okay, making a few steps forward here. One can speak about feminist legal writings on IHL, and it went through basically 3 phases. So the first phase is realizing that IHL is indeed gendered, which is a little bit of what I've been hinting at here in the presentation. And the second phase is raising the discussion about gender-sensitive protection of civilians. So even if the general protection is supposed to be gender neutral, there's a realization that in practice it isn't neutral. And the reason for that is that women and men experience armed conflict very, very differently. And there's quite an increasing amount of awareness or realization to this fact happening these days. And as you know, the third phase, clearly, sexual violence against women is acknowledged as a war crime, and that to a large extent, thanks to the tribunals, the ICTY and the ICTR, and the work they did in the 90s. Now, I want to spend the last few minutes reflecting on war as hypermasculinity. So what we're talking about here, war consists of soldiers, which sort of represents ultra-violence. The right or the permission, let me call it that, to kill another soldier without any legal consequences after the fighting. We speak about victims of war. Often, victims of war are perceived to be women and children. Following the Geneva Conventions, obviously they cover different groups of victims of war, including wounded and sick and shipwrecked, and those out of hors de combat who are not able to fight. Victims of violence, often perceived to be women. Clearly, there's an increasing awareness that even men can be victims of sexual violence, albeit maybe they will never be sort of the the biggest group suffering from such attacks. And what's also sort of coming up more and more is intersectionality. What happens to transsexuals, homosexuals? What type of protection is there, and how does the protection apply, or how much protection can they get from the general protection under IHL? So looking at IHL and actually reading masculinity into it rather than feminism, it becomes obvious that laws of war are merely embody a long-standing masculine ideal. What is legal is what is virile, and vice versa. So there's a very tight connection with masculinity and fighting a war and being in control and being in command and being a man, or masculinity. As we heard Professor Giegerich say just recently in his contribution here, these laws were drafted by men. And that's even more extreme, of course, with the Geneva Conventions, the IHL regime. Partly, of course, because it's historic, it's old. But if you look at the armed conflict, the war, fighting a war, it's a decision by states. States are often perceived male. It's something that happens in the public. The public is perceived as the male arena, and the private arena is then given the anti feature of being female. And the legitimacy, the permission to use violence obviously is also tightly linked to notions of masculinity. And this is the key, according to Maigret. So simultaneously to authorize and restrict violence, because that's actually what IHL does. IHL tries to find the balance of what is permissible violence and what is non-permissible violence. So to simultaneously authorize.
Professor Argren, sorry for interrupting you, but as I announced at the beginning, we are in a bit of a problem regarding time. So if I may kindly ask you to maybe just conclude in a couple of sentences, because we have to really move on with the presentations, although I personally am very much enjoying your presentation. Thank you, and sorry.
Yeah, this is my second last one, so don't worry. Anyway, it means that it's possible to start thinking about the international legal system in a wider scope, rather than just examining IHL isolated in terms of gender. So what's next? Well, I would say that we need to work with what we have. I believe that it can still be the protection given by the IHL regime as it stands today can be expanded based on better analysis on how women actually experience armed conflict. And this is actually happening right now. ICRC has launched a work on women in conflict, gender and conflict, and are exploring, they released yesterday a new report on how armed conflict has different implications for women in that situation. Thank you.
Thank you, Professor Argren. Once again, I apologize for interrupting you. Thank you also for so competently addressing these most significant shortcomings and blind spots in the ability of international humanitarian law to deal with the gender dimensions of conflict. Very, very interesting topic. Also, the fact that you raised, the issue that you raised regarding participation of women in decision-making regarding conflict. So this is also an under-researched topic, it appears, in international humanitarian law, because women are usually perceived as victims and as vulnerable. This dimension is under-researched. Thank you very much. I hope that you have time to be with us until the end for the discussion, and I'm sure that we will have questions later on. Now we go further with the last presentation dealing with this chapter regarding international and European law. And now we actually do focus on the topic for the session today. And I give the floor to my dear colleague and friend, Professor Ivana Krstić, who will talk about the position of women as refugees in international law. Professor Krstić, the floor is yours.
Ivana? The sound is not the best.
Now? It's better now, yes? Okay, good. Because this is how Dan advised me, our computer guy, what to do, but anyway, now it's much better. Thank you so much. Good morning. And I'm really happy that today in the audience we have first of all Bojan from UNHCR, and we also have Kimi from Nigeria. So I hope that they will take part in our discussion later on, as this topic was not included in the textbook that we prepared, but it was a part of my contribution to this Springer publication that Dragica spoke about yesterday. So why this topic is so relevant when we speak about different branches of international law? First of all, the refugee law was blind because we still have the convention, which is the main source and which is 1951 convention, Geneva Convention on the Status of Refugees. And it's a curiosity that when this text was adopted, when delegations discussed the text, delegation of ex-Yugoslavia advocated to include sex as one of protected grounds. However, it was rejected. And when we take a look of this convention, we see that it recognizes persecution only on 5 grounds, and we do not have sex/gender within those grounds. What does it mean? It means that it is very hard to recognize that women can be a specific group and that they can get asylum claim on that ground. So there are 2 ways basically to introduce this ground in practice. First of all is to recognize that in certain country, women, they face persecution, which is so specific that they can be recognized as a social group, which is one of the grounds recognized by the convention. And a second way to do that is when we have intersectionality that we mentioned yesterday, which means that if women are prosecuted on some other grounds which are included, such as race or ethnicity, and then in that specific case, asylum officers will not usually recognize that that persecution was so specific based on their sex, but they will still stay more on this other ground which is present in that case. Here, for a long time, it was important to have this specific approach. which means that we have some other international sources which are relevant here, especially those which were mentioned by Professor Giegerich this morning, which means that we have, for example, Istanbul Convention, which defines what is a gender-based violence. And if you take a look at that definition, it's a very simple one, which says that this is a violence that is directed against a woman because she is a woman or that affects women disproportionately. So that would be the leading form here when asylum officers decide whether we have some specific form of persecution, which is, as I said, gender specific. We also have some other regional sources, which means that all regional human rights protection systems, they have sources on which asylum officers can rely on when they decide on asylum claims. Also, we have CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, which was when this convention was adopted. Again, gender violence was not expressly included in this convention, but we have some general comments which were adopted on the part of the committee, which are relevant here. And very importantly, we have general comment number 32, which specifically says that CEDAW complements the Refugee Convention, because Refugee Convention, as I said, does not include this specific ground of persecution. And also we have that the committee expressed concern how asylum officers deal with this issue, because as we do not include specifically this ground, it means that many claims are rejected in practice because what we look through the male lens. So what is the male experience of persecution? And that's the reason why asylum officers usually do not recognize this specific ground. Another issue which is extremely important is that in this convention we do not have a firm persecution. And there are different interpretations why it is so. There are some authors claiming that at the time when the convention was adopted, the term persecution was so clear that there was no need to include a definition. Nowadays, we know that we need this definition, and here we can rely on the EU Qualifications Directive from 2011, which for the first time not only it gives us a definition of what is persecution, but also within acts of persecution for the first time includes acts of sexual violence and also acts of gender-specific nature. And this is a recommendation too that all national legislation should rely basically on this definition. However, it is important to understand why here we speak about persecution which is gender specific. First of all, because we have some acts which are so specific for women. And again, here we rely on Istanbul Convention, which give us a list of these acts, and what we see here is the trafficking of women, the threat of female genital mutilation, forced early marriage, threat of violence and so-called honor crimes, rape and other forms of sexual violence, and assault, serious forms of domestic violence, forced sterilization, and finally, political or religious persecution for holding feminist or other views and the persecutory consequences of failing to conform to gender-prescribed social norms. However, if you have this list, it's not so easy to find that we have persecution which is based on gender, because it has to be a gradated circumstance. So it has to fall within other elements of the refugee definition. And also, it is extremely important to understand that we have some, for example, that if you take a look at one specific gender-based act, such as, for example, trafficking in women, not all victims of human trafficking can fall under this definition. And that was the one example that I took for this morning, just to explain to you when someone who is a victim of human trafficking can at the same time be recognized as a refugee. There are three situations. The first situation would be if, for example, one person has been experienced persecution during trafficking, and the consequences of that are so severe that that person should not be returned to that country where it faced this experience. The second situation would be when, for example, that person takes part in a criminal proceeding, and then there is a risk of retaliation if that person revealed who are the traffickers, as usually it's a part of organized crime. And finally, the third one is a situation which also sometimes is not recognized by asylum officers, and that is a situation when if that person returning to home country would be exposed to discrimination and ostracism by the society and by families, which is also in some countries very usual thing which happens to victims. So finally, to conclude, and as I said, if you take a look at the jurisprudence, first of all, of the European Court of Human Rights, but also of the Committee on the Elimination of All Forms of Discrimination Against Women, what we see is that many claims are rejected. And they are also not recognized by these international bodies. What's the reason for that? The reason is that usually when that case was when someone submits asylum claim in some country, asylum officers usually, first of all, believe that a witness is not credible. Sometimes they do not seek for certain facts which will bring and build the case to be recognized as for a refugee status. And as I said, the reason for that is that usually asylum officers, they look through the lenses of male experience. So what we can do about it? So that's the main question. There are different ways, and it means that my time expired. What we can do, there are different ways, such as early identification, specific protection, and so on. But Professor Giegerich will continue later on with something that is extremely important for us lawyers, and it means that we need to include asylum, gender-sensitive asylum procedure. So I will stop here and return the floor to Bojana.
Thank you, Professor Krstić, for pointing to the most important problems in the asylum procedure regarding the recognition of this ground for persecution, and also for pointing to the importance of complementarity of different international legal regimes in order to afford proper or near proper protection to victims. We will now continue with the next chapter dealing with gender competent criminal law. This chapter deals with both the general and special part of criminal law from a gender perspective. And again, we will go to our online speaker once more, Professor Strand. Will be the first one to present this chapter of the textbook, and will focus on one very peculiar law in Sweden. So the national law of Sweden will be the topic of Professor Strand's presentation. Professor Strand, I hope that you can hear us and that everything is working. Can you hear us now?
Yes.
Yeah, great.
So,
The floor is yours, please.
thank you very much. Thank you for being part of this excellent conference. I will talk about two specific laws of domestic violence and stalking that we have included in this chapter. So, just a short frame to continue out from the speakers before about human rights. So as a criminologist, my take on my work is that intimate partner violence is a violation of human rights, which is supported by the Istanbul Convention. And my work also deals with domestic violence in both rural and urban areas. So just wanted to highlight that a little bit. About 1 of 3 women is estimated to be a victim of intimate partner violence, which is a part of domestic violence. And looking into rural compared to urban areas, so there are studies showing that it's actually more common in rural or remote areas with intimate partner violence. When we come to recidivism, about 15 to 60% recidivate, depending on how you measure recidivism. In Sweden, it's about 36 to 42%. So it's similar. We are a very rural country, but it's similar to other countries when it comes to recidivism. And by that, we can say that a lot of the intimate partner violence, they are serial criminals. So that the violence occur repeated and are often very severe. When we look into severity, we can see that there are more severe violence in rural areas before reporting. So women in rural or remote areas stay in abusive relationship longer. A lot has to do with rurality, difficulties to leave, difficulties to get support, difficulties to reach police, and so on. There are also studies showing that there are more sexual violence in rural areas compared to urban areas. So when looking into legislation, when looking into risk management and supportive actions from society, we need to take into consideration rurality so that all victims will get access to the help and support that society has available. When it comes to stalking, stalking is said to be an unwanted and repeated communication, contact, or other behavior with the intention or without any concern cause fear for the victims or those who are close to them and their safety, which means that when a couple are in a relationship, it's domestic violence, it's intimate partner violence. When they separate and he continues to follow her, to continue to harass her, that kind of violence will then become stalking. So it's important to separate these two things, because stalking is a type of violence that can occur after separation. And prevalence rates of stalking is not only ex-partner stalking, but it's very common. It's about half of all the stalking committed, it's ex-partner violence. But about 9 to 20% in English-speaking countries, and AG has shown that about 1 in 5 women in Europe have experienced stalking. Recidivism rates are similar to domestic violence, so about between 9 and 56%, depending on how you measure them. So the characteristics of a stalker is that they are obsessive. The cause is one of the most important things for the stalker. So getting her back or getting the children back, whatever the cause is, it's most important for him. In some cases, the cause is the only thing that matters in life. So he can quit his job, he can do just following, searching for her to either retain the relationship, or in some cases, when the stalkers lose hope of retaining the relationship, then there's some of them who commit murder and then suicide. So some of these stalkers are extremely dangerous and needs to be handled by criminal justice system. So the other characterized for stalkers are that the repeated attempts to contact the victims. So they are by definition serial criminals. Stalkers justify their actions, so they think that they have a right to pursue the cause, a sense of entitlement. So it could be, we have children together, so it's my right to have my children living with me, and you are my wife, and it's my right that to have you close to me and that you should live with me. That's how they entitle it. They don't agree upon separation. They don't agree that it's possible to get a divorce, and so on and so on. So that's how they justify their actions. There are other, of course, justifications as well, but an example. They also intrude upon the victim. So the stalker is more important than the victim. they don't care because they are more important than their cause. So that's a little bit information on what differs from other type of violence. So we have two laws, and I will start with the first one. It's a domestic violence legislation, and the law is called gross violation of a woman's integrity, and it's in our criminal code, chapter 4. This is a law that was enacted in 1998. It's an overarching law, so it includes several different crimes, and one can say that the overall aim with this law is that it's really bad that you commit a crime towards your partner, but it's even worse if you do it several times and if that affect her self-esteem. So the idea of the law is that it conducts of several different crimes, and those crimes by themselves are considered minor, so it could be harassment or breaching a restraining order, but there are also more severe crimes as assault and illegal threat, but putting them together will increase the sentence, so a longer sentence, and the idea is also that it should be a prison sentence for those who are sentenced, which is not always the case if you have committed a harassment or breached a restraining order. So that's the kind of the idea. Most countries, including Sweden, include stalking in other laws like these ones, and then the legislation on domestic violence is often used for stalkers. So this is a very specific law which is supposed to be used within a relationship. So for severe domestic violence. The anti-stalking law is pretty much the same. So it's called unlawful harassment, and it's the criminal code chapter 4 section 4b, while the other law was section 4a. So it's this similar idea, but in this stalking law that was enacted in 2011, the first things are the same. It's just different crimes added to the stalking law, because it's also the idea is also that the stalking law could be for other types of stalking, and the more crimes you have committed, then the more severe the crime is, and should also be a longer prison sentence. So why should we then have a specific law for stalking, since we have the other law of gross violation of a woman's integrity? Well, it is important because the stalking behavior in itself includes actions that are difficult to prove as crimes. So this could mean that some of the actions that stalkers do could be part of the minor crimes, and then they could be added together. Most often, only the most severe physical violence are being handled by stalkers. So that's why it's important to have a stalking law. The gross violation of a women's integrity can, of course, be used also for the type of violence coming after a separation. But this will be also very important for domestic violence, since it adds to the severity of the crimes committed. And also, of course, stalking is not only a crime of domestic violence. Risk assessment and risk management are provided only to those who are recognized, meaning you have to report to police or social service that you are the victim of violence. And that's why these two laws are so important. Victims may feel that if they are not being a victim of physical violence, it's difficult to proceed. But these laws are actually saying that all of these crimes within the umbrella law is important and constitutes of a very severe crime. So that's why it's important. Also, that the restraining orders can be part of risk management if stalking is detected by the criminal justice system. So getting access to the restraining orders are also very important when it comes to stalking. And stalking is considered to be a very severe crime. The outcome of the stalking law that was enacted in 2011, so it's about 10 years now, but there was the Swedish government was following this law for the first years, and they concluded that about 7% of the reported crimes were actually sentenced. There was a verdict for them, and they mainly contained harassment, breaching a restraining order, and unlawful threats. And half of them were sentenced to prison, about a quarter to probation, and then a large amount, actually 40%, were sentenced to forensic psychiatric care. More recent updates, when I look into crime statistics, shows that there are less reported. There are about 500-600 crimes a year reported, stalking reported to the police each year, and about 100 of them are sentenced. So in terms of numbers, we are now like maybe 17-18%, somewhere around there, of those who report stalking. So that's where we are at the moment. And the majority of the criminal acts are violence, threat, property damage, and harassment, and all of them goes into this law. So it could be better, meaning that it could be more, of course, more that victim reports, but I think the main problem is that victims do report stalking. It's just that police might not recognize that it is stalking. So there's still this problem with the separate crimes being reported and not added by police or prosecutors. And the same goes for gross violation of a woman's severity, that law. We looked into, we had a specific study in a rural area, and in about 5 years, we had 258 cases. And when we follow them, we could see that about 11% were sentenced according to the law. Another 20% were sentenced for assault, and 4% of other crimes. So they were reported for gross violation of women's severity, but the prosecutor couldn't find the evidence enough for all crimes. So then they went further with the actual the crimes beneath, so the assault, unlawful threats, and breaching a restraining order. So they got sentenced, so about half of them got sentenced for a crime, but only 11% were sentenced for the crime within the law. So, and about half of them were sentenced to prison, and about 40% were sent to conditional sentences or probations. So, and that is also similar to other studies and government studies that also show that there is about 1 in 10 that are sentenced. So it's followed the same both rural and urban areas. Interesting is that about half of the perpetrators actually had a prior convictions for other types of violence towards their partner before getting reported for this crime, which means that both these laws, they work in a similar way. And what we did was, after having investigated and researched these two different laws, we have a research program called the RiskSum Research Program, which is structured risk management model to use when preventing intimate personal violence and stalking, where we'll look into how can we use these numbers, how can we look into what type of risk management can be used, and how can the Swedish social service and the police work more closely when managing intimate partner violence and stalking. We also want to look into the effects of how well the collaboration works. And of course, the ultimate goal is to stop all violence and no recidivism. But on the way towards that goal, we also added that we have to look into victims' quality of life and also look into those who work with these cases, that they will continue and also get help, because these are difficult cases to work with. So we need to maintain also their quality of working life. And for victims, if they understood and that they felt that they got a better quality of life going into and collaborated with risk management, then hopefully they can have a life which is not in secluded or in protective shelters for a long time. That's also a type of violation of their rights, since they have been a victim and they have to take the consequences of
Professor
violence.
Strand, I apologize for interrupting you, but in the
Never.
interest of time, I really have to. Okay, the last slide is there. Thank you.
Yes, that was my last sentence. So, thank you very much.
Thank you. Thank you for such an interesting presentation of the Swedish national legal framework when it comes to stalking. I'm sure that our colleagues that deal with criminal law would have plenty of topics to compare with your the solutions that you have in Swedish law. We continue further with this chapter on criminal competent, on gender aspects of criminal law, but we will now again go back to the topic of our session and focus on an issue related to women as refugees. Our colleague from the University of Belgrade, Faculty of Law, Ivana Marinković, will talk about female genital mutilation as a form of persecution.
Hello everyone, I hope that you can see my presentation. It's a short one, don't burn. Thank you, Nina. Thank you very much. So, hello once again. It's a pleasure to be here. It's a great pleasure to see so many familiar faces. Welcome. And I'm also happy that we have here a colleague from Nigeria, because two of my three cases I will briefly mention later concern actually Nigerian nationals. I'm also happy that there was the great presentation of Professor Krstić, because it fits more than perfectly to my topic, and I'm pretty sure that it will also fit to the presentation of Professor Dadinić. My topic is female genital mutilation as persecution, and I intend, first of all, to give you some general information on FGM, to briefly show the nexus, the connection to the topics of refugees and migrations, to mention three cases, and in the end to underline two misconceptions with regard to this. So, when it comes to FGM, it is basically a crime that is disguised as tradition. The victims are exclusively women, and in this regard, it has not only a gender-specific or gender-based nature, it's more like a gender-exclusive one. Here you can see the definition on FGM. It's the definition of the World Health Organization, and it is universally accepted.
What I would like here to underline is this, that it's done, the removal of the female genital organs for non-medical purposes. Bear that in mind. Because other terms that come up in this issue, and this is very important, it always starts with terminology, female genital circumcision and female genital cutting. Now, first of all, I would like to underline why those terms are not appropriate ones. Cutting, first of all, indicates that it's a less severe intervention, which is here not the case if we bear in mind the problems, medical ones, that follow up this procedure. Circumcision is also wrong because it misleads to the comparison to male circumcision, and it is also anatomically speaking simply wrong. So what we do here actually is basically mutilation, as it is done as written without medical indication for non-medical purposes. It is also important to say that this term is a term that does not trivialize and downplay the issue of the irreversible procedure with no health benefits whatsoever. The consequences are namely short and long-term ones. The procedure of FGM is often performed with rudimentary and inappropriate tools like knives, scissors, glass shards, without anesthesia and in unsanitary conditions. So the razor blade you can see here, it's not a symbolic photo, it is actually used. What follows, you can imagine, is extreme pain, bleeding, shock, psychological trauma, infection, infertility, problems with dysfunctional sexual dysfunctions, problems, painful sexual intercourse, and eventually also death. FGM is not a side issue, a secondary one, as someone may imagine. Right now, there are 200 million women and girls alive that have undergone this procedure. 200 million, you may imagine it's the combined population of France, Germany, and Greece, or it's the whole population of Nigeria, the most populous state in Africa. At current rates, it is further estimated that another 68 million girls and women are at risk to be cut. This is a term that is then used by 2030, most of them below the age of 15 years. Countries with the highest prevalence rates are Somalia, Guinea, Djibouti, Egypt, Mali, Sierra Leone, and Sudan. And you may see there are African ones. Nonetheless, this is not only an African problem, as many tend to say. Just to add, in Somalia, the rate is 98%, meaning that almost all women and girls there have been mutilated. However, as I mentioned, this is not only an African problem, because the problem or the issue has in the meantime migrated and fled to our continent. We see very diverse, very different development right now. Mainly, the numbers in Africa are still very high, but the trend is decreasing. However, the numbers of cut women in Europe have been going up since then. The highest prevalence rates of FGM in Europe are in the United Kingdom, followed by France, Germany, Italy, and the Netherlands. Figures that I mentioned with regard to this are, however, only estimations, because the real numbers are not accessible due to many unreported cases and to the difficult access to the affected communities. Now, FGM as persecution. Professor Krstić gave a wonderful introduction on that, so I will not have to repeat anything. But I just want to say that FGM has been classified as a form of torture and inhuman or degrading treatment, as a violation of human rights, starting from the right to non-discrimination to the right to life. It is also a violation of health and bodily integrity of women and girls. It is a form of gender-based violence that inflicts severe harm, both mental and physical, meaning that to expel or return a girl or woman to a country where she would be subjected to FGM may amount to a breach of international human rights law, as we have heard. However, this view of FGM as a human rights violation, as a crime, or even as just a transgression is not shared by everyone. The main actors, basically the parents and the community at large, most likely view the procedure as upholding traditional, cultural, social, or religious values. So even if they have a sense that this procedure is hurtful, that it does some damage, in the end they deem it necessary. So the consent that a girl or woman maybe gives, if she has been even asked, has to be filtered through the terms and preconditions that, for example, criminal law has developed for this. If we had time, I can mention a case from Kenya in the end, but only if we have time. It's okay, it's okay, it's okay. I was too quick. You can see it. I want just shortly to focus on 3 cases. And in those 3 cases, you can see some of the problems with regard to this question. The first case is from Nigeria. It's the case of Isi Bakari and others versus Ireland from 2011. And it was basically the issue that the applicant feared that the family of the husband would carry out FGM on her daughters if they would return to Nigeria. She also claimed that the elder daughter died as a consequence of FGM. However, the European Court of Human Rights questioned the veracity of her claims, and it was basically in the end dismissed. So credibility issues that Professor Krstić also mentioned came up in this case and also in the others in one way or the other. The second case is from Sudan from 2016. It's Airbnb versus and others versus the Netherlands. And the question there was, or the issue there was regarding credibility, that the identity of them and their previous place of residence in Sudan could not be established, meaning that the court found that it was not established that those applicants did not belong to a group of higher educated people who were able to resist the practice. In other words, the assumption of the court was that there are groups that per se could resist this practice. And the third case is again from Nigeria. It's Collins and Akazibio versus Sweden from 2007. The issue there is that the woman fled to Sweden while being pregnant with her daughter in an attempt to flee FGM that would have been performed on her during childbirth if she had stayed in Nigeria. Now, the asylum application was rejected by the Swedish authorities, explaining that FGM was outlawed by Nigerian law, and rejecting the arguments that it was a deep-rooted Nigerian tradition carried out despite this prohibition, despite this modern law. Later on, the European Court of Human Rights also rejected her claim because she could not substantiate that there was a real and concrete risk of being cut and mutilated there. So beside the I mentioned credibility issues that have led to the rejections of the applications, misconceptions can be deduced from these cases. The first misconception you see below is that the woman can refuse to be cut, or that the parents can protect their daughters from FGM. This became clear in the second case, Airbnb versus Netherlands. We have to understand this, why this is wrong. We have to understand that FGM in countries where it is practiced, it's a rite of passage or an initiation of a girl into womanhood. After being cut, after that, she becomes a woman, basically. Or it can also be perceived as a religious duty, meaning that the persistence this practice relies on social pressures to conform. A good example is Sierra Leone, where FGM is explicitly seen as a sacrifice for the fertility of both the individual and the community. Very often it is assumed that if a woman has not been cut, she will not be able to deliver healthy children, or that she is not marriageable at all. The second misconception is that the woman can relocate. When I say relocate, this means that she can move within the borders of the respective country. And there is the misconception regarding the existence of state protection. Even if the state prohibits FGM laws, the majority of states does so, this does not necessarily mean that the state protection is available. The practice of FGM may continue because it is basically a power that there is some power on local level where the state doesn't even enter into it, or because authorities are simply unwilling or unable to prevent, persecute, or punish perpetrators. And because I think I was quick enough, I would like to mention a case from Kenya. It's a very recent one. There was, or there is, a law prohibiting FGM in Kenya adopted in 2011, and in 2017, there was a constitutional petition before the High Court of Kenya, claiming that the law was unconstitutional, that it was going against the cultural identity of the Kenyan women. The complaint or the petition was rejected in 2021. What's interesting here is that the claimant was a public health professional, a female one, and she literally fought to leave FGM within the legal borders of Kenyan law. What's also interesting, that's what we mentioned yesterday, is that judges on the High Court were 3 women also. And due to the testimonies and the expertise of 3 medical experts, they concluded that no woman would consciously and fully consent to FGM, and that not only is the law that was mentioned not unconstitutional, they even deemed that the law has to be broadened because it did not entail all the definitions, because there are 4 ways of human genital mutilations. The law entailed only 3, and the judges gave a recommendation to include also the 4th form of FGM. Thank you very much for your attention. I hope I was quick enough. Thank you, Ivana. Thank you. Thank you also for respecting the time limit. I really appreciate that, since we are already in a bit of a problem. Yeah. But yeah, thank you. And in order just to relate what you were discussing to what Professor Krstić earlier mentioned, and the issue of refugees, according to UNHCR, estimates 20,000 women and girls a year, it is estimated, are seeking asylum in Europe and have undergone FGM. So these figures are really terrifying. And according to some research, the COVID situation additionally made these figures worse, but there are no statistics there. You raised your hand. No. Okay.
You have to turn on the microphone.
You have to turn on the microphone, but if you do not mind, let's leave for the discussion part. Thank you, Ivana, once again. We now continue with the next chapter, dealing with criminology and penal policy. So I give the word to Natalia Lukic from the University of Belgrade Faculty of Law to present this chapter and also to focus a bit on women and girls as victims of migration. So a bit a more broader scope than just focusing on refugees. Natalia, the floor is yours.
Thank you very much, Bojana. Good morning, everyone. I'll try to briefly present what I intended for today. So I participated in writing this chapter, Gender Perspective of Victimization, Crime and Penal Policy, but since I have already presented a part of this chapter at Redro University in May this year, I tried to focus more today on this topic of the round table, so women on the floor. So I will try briefly only to present some main forms of victimization that especially females suffer from so during their migrant routes, to say. So it is from criminological point of view very important to make first a distinction between 2 crimes. So, sorry, but okay, do you hear me now? Great. Between two main crimes in this respect. The first one would be illegal crossing of state borders, the smuggling, and the other one, human trafficking. So I tried to also make a distinction between different phases or different stages of these migrant routes and journeys. So I would first like to point to some forms of victimization at the first stage, and that is actually in the country of origin. So in many cases, what we can learn from conducted criminological research, many women and girls decide to escape, actually, not for economic reasons, but due to gender-based violence. That could be domestic violence, that could be forced marriage, or as we have already heard, this female genital mutilation. Next, so when they go further, I will present you, for example, results of one research conducted in Serbia several years ago, and Serbia is a transit country, so many migrants actually have no plans to stay here or to seek asylum. According to data, most of respondents in this research said that they had no experience of trafficking, but we should be cautious with that because we cannot be sure whether they know the clear difference between crimes, or maybe they just don't want to report because their plan is to go further and to reach EU and not to stay here for a longer time. So according to these data, about 75% said that they had no experience of human trafficking. When it comes to those who did report this type of victimization, in most cases this included exploitation for sexual exploitation, then forced labor, and situations of removal of organs and forced criminal activities are actually rare, according to at least this research. On the other hand, when it comes to smuggling and their experience with this type of perpetrators, most of them have really negative impressions. So I can just read some of the statements from criminological research. So on the question, would they recommend their smugglers? They said, no, they have great side effect. They don't tell the right situation, they have demands, and they rape females. No, I wouldn't because it's life-threatening and you could die. I was lucky to come out of it alive. No, because it's a terrible experience. You have no respect, and they were treating us like animals. When it comes to certain crimes or certain forms of victimization, so apart from sexual crimes and rape, and according to some estimates, this goes even to 90% of all females who are traveling from their countries of origin to countries of destination. It's really hard to have a precise number. So apart from these crimes, for example, in some cases, it was very difficult to make a distinction between human trafficking and rape, for example, because if migrants, so females, couldn't afford food or accommodation, or they couldn't pay for the next stage of their journey, then they will pay in sexual services. Then there were also cases of extortion. So in one case, one individual was isolated and raped in order to pressure family members to pay money for the release and to continue the journey. So if they finally, and I'll try to finish with that part, if they finally reach their country of destination, it's not that victimization stops. On the contrary, so we have further problems. If, for example, these females haven't regulated their status there, so residency status, they will be more reluctant to report, for example, domestic violence. Then we have also problem of a language barrier, then they will be probably more willful to work in informal economy and to accept to accept in that respect a job without or with limited labor protection, and not to go further with conflict criminological theories that really explain this relation between migration and crime, for example, honor crimes, etc., etc. But I will stop here this moment because I believe that 10 minutes have passed, and I will return the floor to Bojana. Thank you. Thank you very much.
Thank you, Natalia, for this interesting presentation and for raising so many important issues. We are slowly approaching the end and coming to the last two chapters. The first one dealing with gender equality aspects of public law, although the focus of Professor Davinic's presentation would be on gender-sensitive asylum procedure. Professor Davinic, the floor is yours. I will share the presentation.
Thank you very much. And if I may say, after 2 hours of presentations, I can see excitement in your eyes here. So I will really try to be very quick. Just first introduction for the book where Marika was one of the editors who was writing about gender quotas together with Tanasije and Evola. This second book in the series, Gender Competent Public Law and Policies, I was writing about the role of European Ombudsman in strengthening gender equality within the European Union. So what is more logical than today to speak about totally different topic? But Dragica told me, you should you should speak about gender-sensitive asylum procedure, and for me, this is, of course, I understand because this topic much better suits the context of our session this morning. So without further ado, I will start with my presentation. What is gender-sensitive asylum procedure, and what is the meaning behind this concept? Well, this is the procedure that ensures that women are able to fulfill their own rights, and this process assists women to disclose and explain their fears of gender-based violence. Reason behind this concept is that in many communities, especially in countries with traditional societies, rape and sexual assault or abuse carry stigma and shame, and this can be a major barrier to disclosing asylum claims. And where women are treated simply as just a part of the family group, the opportunity to explore the fear is lost, and this individual base, which is so important for seeking protection, can be missed. We can move to another slide. Yes, thank you. Just a few sentences about the main elements of gender-sensitive asylum procedure. First of all, it is crucial to ensure that women have the possibility of being interviewed separately from their family because of those reasons that I explained seconds ago. Then, very important that they have the possibility to express a preference for the sex of the interviewers. Of course, female in 99.9% of all cases will ask for female interpreters and interviewers. It goes without saying that those asylum officials should respect confidentiality of the information gathered through interviews. Care is also taken to avoid secondary victimization or re-traumatization of the women, and sufficient time is very important. That's why I will explain accelerated procedure is not good in these cases, because sufficient time is provided to enable the applicant to build a relationship of trust. And finally, when women testified about the violence, especially about domestic violence, it is useful to have breaks, and breaks are given if needed. There is one phenomenon when we speak about women as victims of domestic violence, that they're often initially unable to disclose the nature and extent of gender-based crime. Unfortunately, it is common practice that asylum officers, decision makers, and courts treat facts disclosed at a later stage in the asylum process as less credible, and of course, it negatively impacts women. And now we will see what can cause this later disclosure. First of all, the intimate nature of many types of gender-based violence against women, then fear of the consequence of such disclosure, feelings of shame and stigma, the effect of post-traumatic stress disorder or another mental health difficulty, and finally being tired or traumatized as a result of the journey, difficult and unsafe reception conditions. I mentioned earlier that accelerated procedure, which is suitable for in some other cases, is not good in these cases. Why? Because gender-based claims are very complex, and women face difficulties in disclosing and properly presenting their claims. There is, of course, real danger that women subjected to such accelerated procedures will be denied protection. That's why it is so important that we have special training for asylum officials. Of course, they should have available training manuals or gender-sensitive asylum procedure. And of course, it is crucial that the entire system, the entire asylum process is gender-sensitive. Gender guidelines should cover topics such as identification of possible victims and those at risk of gender-based violence, list of relevant national and international standards in this field, the gender-sensitive interview process, the impact of gender on the ability to disclose and present an asylum claim, and finally, to consider cultural and religious sensitivities or personal factors. Finally, the last slide as an illustration of this information that I have given to you. I will just explain one case, the case from Canada. The facts are that the claimant was from Ghana, and she alleged that she had been abused and threatened with death by her husband. Unfortunately, police protection was not available to women who were victims of domestic violence in Ghana. The Canadian asylum officials had some doubts at the very beginning, but after that they gave considerable weight to a medical and psychiatric report, both of which stated that the claimant was suffering from depression and post-traumatic stress syndrome. Even though wild lettering was a criminal offense in Ghana, adequate state protection was not available to the claimant, and that's why she was awarded international protection. And I think this case explains very well why we need gender-sensitive asylum procedure at the subnational level, but especially at the level of nation states. Thank you very much for your attention.
Thank you, Marko, for this interesting presentation and for managing to cover so many important issues within such brief time. The guidelines were very, very useful, and also the point that we need additional training in this area for asylum officials. The final speaker for today, last but not least, Professor Tanasije Marinković, who will continue presenting the chapter on gender equality within public law. However, he will also present another chapter on human rights and gender equality. So Tanasije, the floor is yours.
Thank you, Bojana. I would like to greet you all and welcome you once again at the Faculty of Law, University of Belgrade. And I will also take the opportunity at the end of today's session to thank Professor Dragica for gathering us all. It looks a bit weird, but I will particularly thank her for gathering us from the Faculty of Law, University of Belgrade, because we have quite often international conferences at our faculty, but we don't gather so much. The faculty members do not gather so much. And Professor Dragica has this rare gift of bringing people together. So this is a true thank to her. And also for always engaging us in these progressive projects for our society and worldwide. Now, after these praises, I have to express some concerns. It is a great pleasure, of course, to participate in the conference, but the day when I saw this agenda, and especially this panel, I've been stressing and sweating. I'm impressed by the concise presentations of my colleagues, and I hope I will be able to follow them. So, Bojana, how much time?
We are already within the time for discussion. So Tanasije, please, 10 minutes, not more.
For 2 chapters?
Yeah.
Okay, so what I will do, I will really shortly speak of 5 minutes on the chapter on public law and gender equality. Then I will speak for another generous 5 minutes on the human rights perspective in gender equality. Now, this first chapter that I will speak of public law and gender equality, I had the pleasure to contribute to it together with my colleagues, Marko Davinic, who is here, and Eleanor Christopherson from Orebro University. In this chapter, we dealt with the evolution of public law from a homocentric public law through more gender balanced, gender neutral public law towards more gender competent public law. And I will just a few words say something more about this aspect of our chapter, but I will also draw your attention to the topics which were addressed by my other 2 colleagues. So in this chapter, we also address the question of representation of women, political representation of women, as well as the questions of domestic violence and public law responses to domestic violence, and finally, public law mechanisms of enforcement of anti-discrimination law. Speaking of the development of the public law, many of the topics that we addressed more concretely, more specifically, I addressed in this chapter, were also in a way accentuated by the presentations that we could hear yesterday and today. What is important to understand is that public law has evolved in its modern form from a homocentric concept to a gender competent public law. What we mean by homocentric and what is characterized by homocentric public law is actually the public law in its first initial stage, which occurred in 18th century through 19th century to the 20th century. In that period, modern public law was developed in itself, and that modern public law meant that religious affairs were relegated to the public sphere. So there was a switch from a religious state to a secular state, but also a switch from an absolutist state to a liberal state. And these two switches, from a religious state to a secular state and from the absolutist state to the liberal state, had an important consequences for the position of women. The dichotomy of public and private spheres was quite clearly delineated in that period, and that dichotomy perpetuated the social, private, and also public disempowerment of women as compared to men. Women were relegated to the private sphere. The public sphere was reserved for men. And that dichotomy actually contributed to the not only political but also social and economic empowerment of men, and at the same time the disempowerment of women. And feminist critique rightly pointed out the political nature of family in that period, and the political nature of the private sphere in that period, and how much actually that subordination of women to the family life and its subordination within the family life also to the patriarchal patterns of behavior actually contributed to the empowerment of men, not only in the private sphere but also in the public sphere. So there was the fight of the feminist different feminist movements for the gender equality and gender equal public law, so balanced and neutral public law. And that second period development of public law meant actually that equality was seen as sameness, and women were actually insisting on their sameness with men, and they were demanding for the same rights as the rights that men had. And that was the period of different suffrage movements and expansion of voting rights. Nevertheless, as Mariam pointed out yesterday, for example, in many civil law spheres, women continued to be, even legally, not only socially, politically, economically disempowered, they continue to be legally disempowered, and they were unequal in family law, for example, in Germany until the 70s, and in many progressive Asian countries, they continue to be treated differently, legally differently in civil law up until 80s of the previous century. The current stage of the development of public law implied a gender competence, gender sensitive public law, which meant that unlike the first stage in which the differences were used as an argument, the differences which were real or constructed between men and women, which were used as an argument to disempower women, and women were completely publicly invisible. When we spoke in the mid-19th century of the expansion of the suffrage, and when you read, for example, French, English, German authors of that period who speak of suffrage becoming general, they do not take women into account at all. They don't consider women as those who should be understood as beneficiaries of that general suffrage. Well, in the current stage of the development of public law, there is an understanding that differences should account for equality, and that they should be taken into account when we discuss of equality in the public sphere. And this means two things. That equality should be recognized to everyone, not only men and women, but also to non-binary gender. We have cases, for example, in Germany, where through the activism of the German Federal Constitutional Court, the non-binary gender was introduced into German law. And also we have other understanding of gender competent, gender sensitive public law, and it implies actually that we should understand equality substantially and not formally. Therefore, we are going towards suppression of this dichotomy when it comes to protection of women. And the Istanbul Convention that we have mentioned treats exactly domestic violence as public law, which was the agenda of feminist critique for a couple of decades and even century before the Istanbul Convention was adopted. So this is just to portray the development of public law, different stages, and to show that, of course, when we speak of the current stage, we don't speak of all the countries, not even of the Europe, let alone of the world, but of a trend that we are trying to follow. Nevertheless, there are reverse trends, such as the recent judgment of the Supreme Court of the United States, Dobbs versus Jackson Women's Health Center. This is the judgment of the 24th June this year, which reversed, overruled the famous Roe versus Wade judgment and another judgment, the Casey of the 90s, the previous century. So there are also reverse trends. Now I will switch quickly to the other chapter that I contributed to, which is the human rights chapter. There I had the pleasure to work with my colleagues Julia Jungfleisch and Marco Evola. Unfortunately, Marco is not with us today, and I wish he was here because he would have this burden with me of presenting, and pleasure, of course, of presenting this chapter. In this chapter, we dealt with all relevant political, civil, socio-economic, and cultural rights through the gender perspective. The topics that we address in particular were the prohibition of gender-based violence, the prohibition of slavery and trafficking in persons, the freedom of religion, the right to private life, the access to justice for women, women's empowerment, the prohibition of women's economic and social discrimination, and women's right to education. What I wanted to particularly address in today's presentation is actually a problem, one of the examples of the many problems that we have when it comes to gender equality, when it comes to human rights law in general, and that is concretely the conflict which may exist between religious rights, religious freedoms, and gender equality. I wanted to address in particular the question of burqas and burkinis, an issue which basically appeared as a legal problem, a legal question, mostly in this century. There was we probably all know about the French legislation on that matter, but there was even earlier than French legislation in 2010 attempt of Catalonia's parliament to adopt a ban on burqas. The upper chamber of the parliament even adopted the legislation, but then the lower chamber, by a narrow majority, actually refused to confirm that legislation. After that, many other cases appeared before the European Court of Human Rights, before the International Committee on Human Rights. And what is interesting is that we see a differing case law in these two international bodies. So in SAS versus France, the European Court of Human Rights took one position, that burqas, prohibition of burqas was acceptable in the context of the French constitutional identity and the concept of living together, but that on the other international level, the International UN Committee on Human Rights actually considered that such a vague concept, constitutional concept of identity, the vague concept of constitutional identity in France cannot trump over freedom of religion, which implies the freedom to express one's beliefs by wearing burqas. So there is I take these two cases as paradigmatic. There are many other cases in the European Court of Human Rights which are relevant for this perspective. There are other domestic cases. There is recently a case of headscarves, also decided by the European Court of Justice with respect to two decisions, the two preliminary requests made by two German courts. Just to pinpoint the importance of this question, we're here at at this dilemma, how to balance these two values. On one side, the importance of religious freedom in its external dimension, meaning right to observe certain religious practices, which on the other side may lead to the subordination of women, because in its collective institutional dimension, we see that that women are very often bear the brunt of these religious freedoms. So religious freedoms for women, but also obviously religious freedoms against women. On the other side, and there is also a debate among philosophers as well, Martin Nussbaum, Michelman, and the others have taken different views on this position, whether actually at all this violates gender equality, and whether we should rather treat this question of wearing burqas as indeed a question of religious freedom of women, their right to express their views in this way. I'm sorry that I couldn't detail all the aspects of this presentation, of this aspect of this question, to which I attach a particular importance, but due to the time constraints, I will limit myself to this much and give opportunity to you actually to maybe ask questions and to give comments and continue this discussion within the Q&A session of this panel. Thank you.
Thank you, Tanasije, for so competently leading us through the stages of development of public law and its gender sensitivity, and also for shedding light on these important and particular issues regarding human rights, religious freedoms in particular. Without further ado, I now open the floor for comments and questions. Please.
Thank you. To present myself firstly, I'm Zorica Mušević. I am professor from Faculty of European Legal and Political Studies in Novi Sad. Currently, actually, I used to work 40 years in Institute of Social Sciences. And anyway, regarding religious aspects of wearing burqa or headscarves, I would like to say there is no religious component. This is simply a misogynistic standpoint that women are dirty, women provoke if visible decorated part of hair or pieces of skin. And this is something that legally drive men to be mad. To behave violently towards women, towards other men as rivals, and women are responsible for their violent behavior. That is the root of a burqa. Nothing is written in Quran in regard of covering. Moreover, it is said that the duty of men and women are to watch each other, to wear eyes, meaning to have eye contact. Anyway, it is a completely misconcept to treat duty of wearing burqa as something religious, and then, of course, like religious freedom, and of course, freedom of choice, etc., etc. In fact, this is the way how to transfer responsibility of men to be violent on women. Women are guilty. Women are responsible because they provoke. And men could not resist. Normally, they see that little part of women's body. What to do then? Tolerate her. This is normal men's behavior. In the same time, these men of Muslim religions don't become mad in Western societies. in everyday contact, they are communicating with hundreds of half-naked women and didn't become mad and didn't rape anybody and didn't attack anybody, meaning they can control themselves. And everybody can control themselves, not to mention any kind of religion. Anyway, we cannot change the standpoint of constitutional courts of France or any European stage, but just to be aware that what is the real root of obligation of women of Muslim religions to be covered. This is not a religion, but something else. Thank you for your attention.
Yeah, thank you, Zorica, for your intervention. There are indeed different interpretations of Quran in that respect, as it usually comes with these sensitive topics and religious scripts. So there are interpretations which lead to one standpoint. There are interpretations which lead to another standpoint. I would agree with you that burqa denies human dignity and specifically the right to individual personality by rendering individuality invisible. So I would entirely agree with you on that point. However, we cannot take we have to take into account as well that there are women who wear burqa voluntarily.
Also, this is the family respect. This is the structural way of it.
Yes.
Nobody's like that and ask, no, you won't go out, put it down. It's not for discussion at all. If I wear Muslim belongings, I will wear it with proud. This is my culture.
And, indeed, and this is under the pressure of patriarchal, cultural, religious practices within which they were born and within which they were raised. So the real question is how to find whether it is possible at all to establish a test by which we would be able to understand whether burqa is born voluntarily, whether burqa is worn voluntarily or not. So this is what I'm also trying to find as an answer in my research.
Thank you, Professor Damir Banović.
Thank you. I think yesterday we were talking about this female perspective, or actually woman's point. And when talking about burqa and scarves, I think it's also very important to have women who are wearing some kind of scarf or burqa or whatever present also here, and to have her standpoint in that case, because I mean, I know females who wear burqa, and I don't think they're suppressed in this kind of sense. So I think it's very important to have their standpoint, because yesterday we were talking about this also female methodology or methodology within the female studies, and this standpoint is very important to have. That's so. So when we discussed on these topics. Secondly, very much appreciated. I mean, also from the others, but always when we have this female mutilation, it's really so scary and horrible practice. Sometimes, I mean, this is more of a comment. When I was in England, there's also, I mean, you can put this within the broader concept of genital autonomy. And when I was in England, there was also this on the male circumcision. Nobody actually talks about it, even though it's much worse when it comes to women. Because I mean, I'm coming from a country where this is something, it's a social practice. Nobody actually talks about it. Then there are like also men coming into these sessions or who experienced the circumcisions mostly in the Jewish community, Islamic community, and some Protestants also. And they had really severe psychological, emotional, sexual damages.
This is just a comment. I mean, we have focused more on female mutilation, but maybe we should also cover this part, which is also related to male. This is something which is also accepted in our society. And if you're actually against it, I mean, no one actually against it, but it's really like it's usually our boys among 4 till 7 years old. No one really asks them if you really want to be circumcised.
Exactly. Thank you, Damir, for the comment. The issue was raised in Germany, in Cologne, at the municipal court, where it decided that male circumcision adds up to serious bodily harm. And there was a big discussion started within the German society, but then at some point it was stopped and remains to be continued. In regard to this, I think the main issue why it's not that much discussed, as you said, it's socially adequate, it's socially accepted, and also the consequences are less severe for women. It's also an issue also is that Buddhism, for example, the boy has to be cut within the first 80 days after being born. So there's absolutely no way to give any consent or anything at all. And one of the reasons why this issue was not discussed as much as it maybe should have been is because of the question of religious freedom. So thank you very much for your comment. I fully agree with you. And I just want to shortly address the previous question of Marion, why the number of FGMs was raised during COVID. Human genital mutilation is something that happens in the background, behind curtains. And during the COVID crisis, almost all of us were confined to stay at home, so there were more opportunities to do the cutting, and it's also a private matter. It is regarded as such, even by the state, even if there is a law that prohibits FGM. So this is the reason why the numbers went up during the corona crisis. It is also the reason why the numbers of the rates of domestic violence and also increased during that time. Thank you. Thank you. We have one more question. Yeah, please.
Hello, everyone. My name is Kemi. I'm from Nigeria, and I'm so happy to be here today. I was here about last month, a month ago, to talk about this female genital mutilation and to talk about what refugee women go through when they are on the journey coming to unknown destination. So I am so happy that the professors refused the topics and they put more light on it. So I'm so happy and I'm so honored about that. And then to talk about what Professor talked about training the asylum officials. I think it's really important to do that. And then if I'm permitted to do that, to join them, I would like to be part of the training. If it's okay? Yeah, thank you.
Thank you. Do we have any more questions? There is one in the chat. Sorry. It's for Professor Damir. Okay, Bojan. Yes, just a second point for Professor Damir. Although it is important to hear women and their opinion on wearing burqas, how will we be able to distinguish whether women are wearing it willingly or are they oppressed and internalized the need to wear them because of patriarchal norms, and what is expected from them as so-called modest Muslims? Yeah, so we have a question for you, although you are not our panelist, so if you wish, maybe just briefly.
No, I mean, this is going to be a completely different. I'm just asking for a woman to be present also. To present a case. So, I mean, I don't want to be the one who is going to distinguish this, what is social oppression, what is, because, for example, we have also this discrimination of covered women. I mean, in our society, like women discriminate their women who are wearing scarves. And also I know women who wear scarves who are actually pushed, I mean, not like actually discriminated from their family because they want to wear a scarf. So I mean, where is this social pressure then? It's really like case by case. I can't say, okay, all women who wear scarves are actually discriminated, but also nuns wear some kind of scarf also. I mean, you also have in the Christian tradition, like my grandmothers, one is from the Christian side, one is from the Muslim side. They both wear scarves. I mean, they never saw. I mean, and my my grandmother, she's from Muslim tradition. She got divorced, so I mean, there was no social oppression in sense of like, there was more social pressure not to divorce compared to wearing a scarf. So I mean, I don't want to talk about it if we don't have a person who is wearing a scarf present here to have this standpoint. That's my actually.
Thank you. We have Kimi actually, and she wants to intervene. Please.
Yeah, talking about the scarf, I'm a Muslim and nobody forced me to be wearing a scarf. As a matter of fact, my mother doesn't wear a scarf. None of my family wears scarf. I'm the first person that started wearing scarf because of my own belief. When I went to madrasa where we read Quran, and I say the reason to wear scarves. Not importantly, maybe you should cover everything if you doesn't want to. So we have different stages. Then I choose this. Maybe later I can decide to put more, but as it is now, I put this. So some family maybe that brother doesn't want to put on, but they put pressure on them because of the family background. That is those people they call like scholar or something. But me, I didn't come from a scholar family. But I went to the madrasa, I read about it, and I love to put it. I don't want to expose my hair. So nobody forced me. And my mom, I remember my mom complaining about this, like, don't you feel heat? Let your hair breathe. I said, okay. That is my own belief. I want to put on shoe. Yeah, so I just love to put. It's not pressure, just the personal decision.
Thank you. Thank you for sharing your personal opinion regarding that with us. And the last question or comment for today, our dear colleague from UNHCR, Bojan Stojanović. Bojan, please, the floor is yours.
Thank you very much. That's the truth. Can you hear me? Okay. Thank you. I will try to speak about the asylum system in Serbia in short, because I prepared some kind of review about this asylum system and situation in Serbia in general, about asylum seekers, refugees, IDPs, etc. You know that according to UNHCR statistic, in this situation we have more than 100 million forcibly displaced persons in the world. Last year, that number was 89 million. But you know, the situation in Ukraine that about 12 million people are forcibly displaced. Some of them are in the territory of Ukraine, and about 5 or 6 million people left Ukraine. For Serbia, I will try to rearrange my paper. It's that in Serbia, according to the Serbian law, each foreigner who is in need of international protection has a right to apply for asylum. Serbian law on asylum and temporary protection regulates asylum procedure and prescribes rights and duties of asylum seekers and refugees in Serbia. UNHCR supports Serbian asylum system and state authorities in this procedure. The office of UNHCR was established in 1976 in the former Yugoslavia, but more than 45 years supports asylum seekers, refugees, IDPs, stateless persons, and returnees. In its activities at the field in Serbia, UNHCR works with its partners organizations. At this moment, UNHCR has 11 partners organizations. Of course, UNHCR supports Serbian authorities in this field and advocates for gender-sensitive aspect of interpretation of 1951 Geneva Convention that supports LGBT asylum seekers and refugees. Also, UNHCR supports other vulnerable categories of forced displacement persons as unaccompanied or separated children, persons with disabilities, elderly persons, etc. And short review about statistics in Serbia. Since April 2008 and to the end of May this year, 210 persons in need of international protection received any kind of international protection. 112 received refugee status and 98 subsidiary protections. Some of them were victims of gender-based violence in their country of origin or during their journey from country of origin to country of destination. And I will try to say something about situation relevant for Ukrainian refugees in Serbia. Since January to the end of June 2022, in Serbia was registered entry of about 53,000 people from Ukraine. That's about 51,000 left Serbia. Many Ukrainian refugees do not perceive Serbia as a destination country because most of them just transit through Serbia because they go to Croatia, to Montenegro, Croatia, or to other EU member states. But of course, they have a right to apply for temporary protection or for asylum, for refugee status. And this is in short. I'm sorry because I know that time is expired.
Yes, the time is up, but thank you, Brian, for sharing this very important data with us. I would also kindly ask you maybe to send us by email what you prepared, because it would be valuable when drafting the final report regarding this conference. Thank you all for your attention. I think that we're all a bit tired and need a break, so let's have Professor Vujadinović. When will the next session start? Now it's 12:10.
Be healthy and it is there 25 minutes.
3 minutes is enough.
Thank you, and thank you for those who participated.